Good evening, everyone. Thank you all for joining us today for this lecture series on domestic and international arbitration. This lecture series has been organized by Prudentia Partners, L.I.K.E, Legal Information Knowledge and Expression, in association with Center for Research in International and Comparative Law, MLNU, Aurangabad. And Legitquest is the knowledge partner, along with LegitEye as the media partner. Prudentia Partners, founded in 2016, is one of the fastest growing law firms in Delhi, equipped with very versatile team of attorneys dedicated to provide best services in a wide range of legal services across sectors such as civil, criminal, matrimonial, electricity, telecom, environmental, banking, and commercial litigation. L.I.K.E is an online one-stop solution for all the updates of the legal world, with a goal to provide a platform to other budding brightest legal minds and ignite the culture of debate and deliberations across the fraternity. Maharashtra National Law University, Aurangabad is an institution established in the year 2000. Education. Legitquest is an artificial intelligence-based legal research product. It is a state-of-the-art legal research platform for conducting legal research and is very well known for the introduction of the world's only one-click insight system called the iDraft Case Analytics. In short, the iDraft feature powered by artificial intelligence takes out the issue, facts, arguments, reasoning, and decision of a case law. Legitquest has recently started with LegitEye, which has the latest news, interviews, and columns and serves the stakeholders of judiciary. Now, moving forward, our today's topic is conduct of arbitral proceedings, and I am deeply honored to have Mr. Vikash C. Shukla as our esteemed speaker today. Mr. V.C. Shukla is one of the founding partners in Prudentia Partners and is an experienced litigator for several years. His fora of practice includes the Supreme Court of India and several high courts, various tribunals such as TDSAT, APTEL, and DRAT. He's a seasoned lawyer in appellate forum for service, education, electricity, consumer disputes, civil, criminal, and arbitration cases. He specializes in emerging fields such as sports law, IPC, and labor reforms in the private sector. He has worked with Shri P.S. Narasimha, the then Additional Solicitor General of India, and assisted him in litigations of national importance and involving critical legal issues. He has also been an integral part of the mediation between the BCCI and the various state cricket associations in implementing the reforms suggested by the Justice Lodha Committee. In addition to the professional association, as mentioned above, he has represented clients like DMRC, Joy Lucas Private Limited, J.K. Simmons, Videocon Group, and several distinguished citizens of the country. So before we start, let me brief you all that our today's session will be for 45 minutes, followed by Q&A. I would humbly request all our participants to please be on mute and without video throughout the call. And all questions to the speaker can be written in the chat box, which will be taken at the end of the session if the time permits. So we seem to be all set. I would now hand over it to Mr. Shukla now. Over to you, sir.
Thank you so much for the introduction. As we've already been told, that today's session is about conduct of arbitral proceedings. So before we start, I would like to introduce you why this chapter in the Arbitration Act was important. As you will see, there's a specific chapter 5 which deals with conduct of arbitral proceedings, which is under the Arbitration Act in India. Now you'll see that in the first 4 sessions which were taken by my friend Aishwary Vikram, he's explained and introduced you to this whole aspect of arbitration and why it is essential. And we all know that in India, there are so many cases pending today, more than 2 crore cases pending today before the courts, and only approximately 22,000 judicial officers to take care of those cases. So arbitration, of course, is a very good way of accumulating those cases and leading adjudication to a conclusion. Now, when we talk of arbitration, the procedure or the way it will be conducted is an important part of arbitration. But as you must have seen in the arbitration agreement lecture, which was done a couple of days back by my friend, he's explained as to what are the essential requirements of an arbitration agreement. If those requirements are fulfilled and an arbitration agreement takes care of these things, then this chapter will not become relevant. You will see as we will proceed in this chapter that whatever essential features need to exist under an arbitration agreement are given here. Now we all understand that arbitration as a procedure itself is a procedure where party autonomy is of most significant importance. The moment we say party autonomy, that means that if parties decide on the procedure, if parties decide as to how they intend to conduct the arbitration, then there'll be no need of this chapter. For example, if the parties decide as to what will be the seat of arbitration, what will be the language of arbitration, what will be the procedure adopted during the course of arbitration, then this chapter will become redundant. It is only in cases where the arbitration agreement itself is not very clear, then this act, by way of abundant caution, has given certain uh, way out. That is, the parties have not agreed. Now, once the arbitration as a regime is developing, we will see that every country, and in a country more than one, several institutions are coming up for arbitration. Now, what is the benefit of these institutional arbitrations? What happens is that the moment the arbitration clause says that the arbitration will be conducted by X institution, let's say it says New Delhi International Arbitration Center, or it says Singapore International Arbitration Center, or London International Arbitration Center, then half the problem again vanishes, because these institutional arbitrations themselves have a very detailed procedure for conducting arbitration. So if the arbitration agreement is very clear, then the necessity to refer to this chapter will arise on a very minimal ground. Or if the arbitration has been referred to an institutional arbitration, then the procedure which is given for that institutional arbitration center will be followed. But if both these cases do not exist, let's say if the arbitration agreement is not very detailed, or it does not specify all those requirements which are essential to exist in an arbitration agreement, or if the parties have not referred it to an institutional arbitration, then this chapter becomes relevant. This chapter 5 has overall 10 sections from 18 to 27. We will go on every section one by one and see as to how it helps during the proceedings in the arbitration. First is section 18, which says equal treatment of parties. When you look at the title of the section, equal treatment of parties, it very well reminds you of the principles of natural justice, audi alteram partem. How will the arbitrator or an arbitral tribunal ensure that parties are treated equally is all that section 18 says. That when an arbitration proceedings has been initiated, then it is the profound duty of the tribunal or the arbitrator to ensure that both the parties are treated equally. In order to do that, what are the most important features which the tribunal or the arbitrator must take into account is that it should be very clear that the claim or the statement of defense which has been submitted by the respondent must be exchanged between the parties. They must be properly notified about the dates of the proceedings. They must be properly notified about the venue or the place where the arbitrations will happen. um, if the parties agree that the evidence or the witnesses will be examined, then proper notification should be given. So all that section 18 says is that both the parties should be treated equally. So the arbitrator must not proceed in any biased manner, or he should act with all impartiality. He should not hear one party in the absence of other party. He should not exceed his jurisdiction. So the way Lord Denning said, that justice should not only be done, it should be seen to be done. So section 18 in the Arbitration Act is all about that. So if something correctly is done in an incorrect manner, then also that leads to bias or arbitrariness. So it is not essential that something is if it is done correctly, that's all. It should be done in the correct manner, is what section 18 says. So for example, in a case where one party approached the arbitral tribunal and sought an adjournment of a single day, saying that my lawyer is busy in another arbitral proceeding. But the arbitrator did not grant that adjournment and proceeded ex parte and passed the award. And the award was subsequently challenged. The High Court said that the award is not correct because the arbitrator ought to have given a day's adjournment, because this was the first time that the party asked for an adjournment. The arbitrator cannot misapply a law, or it cannot ignore a law. In fact, there's a case of Delhi High Court, Rational Intellectual Holdings Limited, where the arbitrator proceeded on certain findings which were based on his private research or on his private knowledge. So when the award was passed, the other party challenged that award, saying that this award has been passed by the arbitrator based on his private research or based on his private knowledge, which was never pleaded by the other party. So whether this award is correct or not, and the High Court agreed, and the High Court said, no, the award is not correct, because the arbitrator ought to have proceeded based on the pleadings which were presented before the arbitral tribunal, not based on his personal knowledge or based on his personal research. So section 18 talks only about following certain basic principles of natural justice, that arbitrariness or bias or impartiality or ignorance of law or misapplication of law shall not be done. One party shall not be treated differently. That is all section 18 says. After this, we move to section 19, which talks about determination of rules of procedure. While dealing with today's discussion, I will read sections and then try and explain as to what is the intention of the section. So when section 19, which says determination of rules of procedure, clause 1 of it says the tribunal shall not be bound by the Code of Civil Procedure or the Indian Evidence Act. Clause 2 says, subject to this part, the parties are free to agree on the procedure to be followed by the arbitral tribunal in conducting its proceeding. Clause 3 says, failing any agreement referred to in subsection 2, the arbitral tribunal may, subject to this part, conduct the proceedings in a manner it considers appropriate. And 4, the last clause says, the power of the arbitral tribunal under subsection 3 includes the power to determine the admissibility, relevance, materiality, and weight of any evidence. So section 19, which talks about the procedure, it says that the arbitral tribunal is not bound by CPC or Evidence Act. So the most important thing is the necessity to refer to arbitration is because in normal parlance, it is believed that a civil case or a civil suit will take approximately 12 to 15 years to lead to conclusion. So if the same procedure was to be applied to arbitration acts also, then obviously the same delay will happen during the arbitration proceedings as well. So that's why the first clarification which is given in clause 1 is that the tribunal is not bound by CPC or the Evidence Act. So that those technicalities of law which sometimes delay the proceedings shall not remain. That's why this precaution is given, that the tribunal is not bound by CPC. But the moment it says it's not bound by CPC does not mean that whatever is written in CPC is not applicable to arbitration proceedings. It's not like that. The generic provisions or the general principles of CPC or the Evidence Act will apply to arbitration. But word by word application of CPC or the Evidence Act is prohibited. Only to avoid the delay. If that procedure will again come here in the arbitration proceedings, then it will lead to the same conclusion. And that is why recently in 2018, Justice Ashok Bhushan in SREI Infra Finance Limited, it is 2018-11 SCC 470, where Justice Ashok Bhushan has categorically said that not bound by CPC and Evidence Act are only words of amplitude and not of restriction. So if there arises a circumstance where both the parties agree for a particular procedure, and it is under the discretion of the tribunal or the arbitrator to apply that principle of CPC or Evidence Act. So it is not a strict principle that any procedure or anything which is mentioned in CPC or Evidence Act will not be applicable. In subsequent proceedings, we will also see that in this chapter only there are certain provisions which actually refer that proceedings of CPC will become very essential for the conduct of arbitral proceedings. We will see. Then one thing which we've been saying from the very first day, that arbitration is something which is where the prime significance is given to the party autonomy. So if the parties have agreed to a particular procedure, the tribunal will definitely agree to that procedure. If the parties have not agreed to any procedure, then it is the tribunal which will lay down a rational procedure to complete the arbitral proceedings. All right. So if the why this distinction from the CPC and the arbitration proceedings was very essential, as I have already explained it to you, to avoid those technicalities which led to certain delays. But at times it becomes problematic also when there is no fixed procedure mentioned. A very good example would be a Union of India versus Singh Builders Syndicate. It is a 2009 5 SCC 523, where Justice Ravindran was caught by a peculiar problem. What happened herein, a public sector undertaking had entered into an agreement with the state government, state of Orissa herein. And the agreement was very categorical that in terms of a dispute, 2 officers of the state government will be appointed as arbitrator and the proceedings will go on. Now, when the dispute arose, the party approached the chief superintendent engineer and he appointed 2 officers of the PSU. During the proceedings, one of the officers was transferred. Then obviously the proceedings were terminated and the party approached again the chief superintendent engineer. He again appointed 2 officers as arbitrator. Now again the proceedings initiated. When the proceedings were going on, then one of the officers, he superannuated. That means he retired. Then again the proceedings were terminated. So the third time when the matter reached before the High Court in Section 11, so the High Court appointed a retired High Court judge. He was a retired Chief Justice of High Court. Now one of the parties challenged it and the challenge reached up to the Supreme Court level. Now in the Supreme Court, the judge asked one of the parties that, what is it that you have a problem if the High Court judge has been appointed as an arbitrator? Now the party submitted before the Supreme Court that the claim is very small, but if a retired High Court judge is appointed as an arbitrator, his fee is such that if 15, 20 proceedings of arbitration go on, it will surpass the claim amount. So that kind of difficulties also arise if the procedure is not mentioned and not given. So Lord Denning, again, as a guiding light, he has said that strict procedures were not given in arbitration proceedings because it was the intention of the legislatures not to stick parties to those technicalities because of which delays happen. But then there are certain mechanisms which talk about procedures, and we will see in the next provisions as we move ahead. The next provision is Section 20, which talks of place of arbitration. Under this chapter, I still believe is one of the most controversial provisions. Why I say controversial is because till date, the Supreme Court has been laying law on this and law is still not clear. And we will see how. Now, place of arbitration, clause 1 says, the parties are free to agree on the place of arbitration. 2 says, failing any agreement referred to in subsection 1, the place of arbitration shall be determined by the arbitral tribunal having regard to the circumstances of the case, including the convenience of the parties. 3, notwithstanding subsection 1 or subsection 2, The arbitral tribunal may, unless otherwise agreed by the parties, meet at any place it considers appropriate for consultation among its members, for hearing witnesses, experts or the parties, or for inspection of documents, goods or other property. Now, the problem here which arises is this, that you will read section 2 subclause E of the arbitration agreement, which talks of courts, as to which courts will have jurisdiction. And this section 20, which talks of place of arbitration, has a nexus with section 2E. The place of arbitration will lead to the jurisdiction of courts. Now, it so happens that the place of arbitration might be in New Delhi, but for some hearings or for some proceedings or recording of witnesses, the arbitrators may sit in Mumbai or Calcutta for a couple of hearings or for 3-4 hearings. So that may be the venue of arbitration, but not the place of arbitration. But at times it so happens that the arbitration agreements are not very clear regarding the place of arbitration or the venue of arbitration. The place of arbitration decides as to which courts will have the supervisory control over the arbitration proceedings. There are certain cases which are very important. One of such is Balco, which laid down the law in this regard. But Balco also had a problem. What Balco did is Balco talked about concurrent jurisdiction. So what Balco said is that in an arbitration agreement or during an arbitration proceedings, 2 courts may have concurrent jurisdiction. How Balco reached that conclusion is by this. It said, it gave an example in paragraph 96. If you will read Balco, you will find this illustration which I am referring to. It said that the parties may be from Calcutta and Bombay. The agreement might have been signed in Calcutta. Part performance of the agreement might happen in Bombay. But because the seat of arbitration is in Delhi, so the courts in Delhi will have supervisory jurisdiction. But at the same time, Balco in para 96 said, because the agreement in part is being performed either in Calcutta and Mumbai, so those courts will also have jurisdiction. So this created a lot of confusion. In Harmony Innovation Shipping Limited versus Gupta Coal India, it is a AIR 2015. The arbitration clause was such that everything was performed in India, but the seat of arbitration was set in London. But the arbitration clause was very clear that the governing law will be English, the contract law will be English. So that's why there was no difficulty. But in another case, Enercon India versus Enercon GmbH, what happened is that the seat of arbitration was London, but the governing law, applicable law, contractual law was of India. That is where again the court said that because the governing law and the contractual law is Indian law, so the place of arbitration would be India. Recently in Antics Multimedia, a Delhi High Court division bench ruled in view of Balco, which is still pending before the Supreme Court and sub judice. But there is very important decision which we all must take note of is BGS SGS Soma JV versus NHPC Limited. This is a very recent judgment given by Justice Nariman. The citation is 2020 Volume 4 SCC 234. Now, why this judgment is important is that although Antrix is sub judice before the Supreme Court, Justice Nariman, while deciding this case, said that the findings of the Delhi High Court in Antrix Multimedia are incorrect. In addition to that, even though this judgment is a 3-judge bench, Justice Nariman further clarified Balco 96 paragraph, which I just referred. So the facts of this case are peculiar. What happened is that an arbitration agreement existed, which said that the place of arbitration would be New Delhi / Faridabad. The agreement was signed in Faridabad. The the contract was to be performed in Assam. When the dispute arose, the arbitration was initiated in New Delhi. Approximately 300 hearings of arbitration happened and an award was passed. Once the award was passed, a section 34 was filed in a Faridabad court. The Faridabad court allowed that 34 but immediately before allowing that, a 37 was filed before the Punjab and Haryana High Court, saying that a seat of arbitration is in Delhi. Hence, this application, which is or the appeal which is filed before the Faridabad court, should be transferred back to Delhi. And the Punjab court allowed that 37, which was impugned before the Supreme Court, in which Justice Nariman clarified BALCO and said that BALCO, even though in the facts and circumstances talked about concurrent jurisdiction, but when in this situation, when both the parties are from India, the arbitration is happening in Delhi, the laws governing is Delhi, then there is no choice of confusion. And Justice Nariman, referring to Section 2, subclause E, read with Section 42 of the Arbitration Agreement Act, said that such court cannot be two courts. And he tried to bring harmonious construction in BALCO 96 and BALCO 98, saying that such court cannot be two courts, so it has to be a single court. And for that Calcutta and Mumbai illustration, Justice Nariman said that in no way it can be said that all three courts will have jurisdiction. Whereas it is very clear that because the arbitration was happening in Delhi and the seat of arbitration was in Delhi, hence the courts in Delhi will have the supervisory jurisdiction. So that is why this place of arbitration is very important. Now, moving forward to the next section, which is Section 21, which talks about commencement of arbitral proceedings. It says, unless otherwise agreed by the parties, the arbitral proceedings in respect of a particular dispute commence on the date on which a request for that dispute to be referred to arbitration is received by the respondent. Now, why this provision is important here is that in a civil suit or in a civil proceeding, there's a guiding light of Limitation Act, Section 5, which prescribes limitation for all cause of actions which may arise in a civil proceedings. But the moment we talk about Arbitration Act, the civil suits, as soon as they are filed before a court, it is considered that they have commenced. But what will be the triggering event in an arbitration proceedings? Because the arbitration proceedings may vary as to cause of action will arise when the dispute arises. There'll be a dispute in this regard also as to when the dispute has arose. So 21 very categorically clarifies that the moment one party sends a notice to the other party for invocation of an arbitration and for an appointment of an arbitrator, that notice will be the triggering event. That notice itself will be said that the arbitration proceedings have commenced. So the commencement is important from the point of view of limitation, and that is why Section 21 is here. Next is Section 22, which talks about the language. Now, language, again, as I had said in the very beginning, that these days most of the arbitration clauses, they talk about language. But if they do not exist, then it says, Clause 1 says the parties are free to agree upon the language or language to be used in the arbitral proceedings. Clause 2 says, failing any agreement referred to in subsection 1, the arbitral tribunal shall determine the language or languages to be used in the arbitral proceedings. 3, the agreement or determination, unless otherwise specified, shall apply to any written statement by a party, any hearing and any arbitral award, decision or other communication by the arbitral tribunal. 4, the arbitral tribunal may order that any documentary evidence shall be accompanied by a translation into the language or languages agreed upon by the parties or determined by the arbitral tribunal. So now this, if you'll see, one thing is very important, that language of any proceeding is very important. There's no doubt. But this 22 also refers back us to section 18, which talks about equality of parties. So it may, because if there's an international commercial arbitration happening and one party is from China, the other party is from let's say India. So now most of the documents of the Chinese party may be in Chinese. So they may bring on record those documents, but it will be of no help to the other party. So to bring equality, this as a matter of, again, by way of abundant caution, has been established here under the Act to provide that there'll be a language settled between the parties. If the parties have not settled the language, then the tribunal or the arbitrator will decide upon the language, and the pleadings and the documents which are to be here will be brought in that language only. If the documents are not available in that language, then it is the responsibility of the party producing that document or relying on that document to bring translated version of that document in the language agreed. All right. So now we move to the next section, which is a very important section. Statement of claim and defense. This is section 23. Why I am saying is it is important is it is here that in effect the proceedings before the tribunal start. Now, as soon as an invocation notice has been sent, either the parties will agree for an arbitrator or an arbitral tribunal, or if the parties have not agreed, one of the parties will approach the court and get an arbitrator appointed or a tribunal appointed. Once the arbitrator or a tribunal has been appointed, then the parties have to file a statement of claim, the petitioner or the claimant as the case is. Once the statement of claim has been filed before the tribunal or the arbitrator, the other party, the respondent or the defendant, will file its statement of defense. Along with the statement of defense, it may file a counterclaim or a set-off as the case may be. Along with the statement of claim and the statement of defense, they will also have to bring on record the documents which they are relying, or they will have to at least refer those documents which they intend to rely during the proceedings before the tribunal. So section 23 is important because it actually prescribes the steps or the procedures substantially which will kick the proceedings before the tribunal. We'll read these provisions as well before proceeding further. So 23 clause 1. Within the period of time agreed upon by the parties or determined by the arbitral tribunal, the claimant shall state the facts supporting his claim, the points at issue. These points are very important. The claimant shall state the facts supporting his claim, the points at issue, and the relief or remedy sought, and the respondent shall state his defense in respect of these particulars, unless the parties have otherwise agreed as to the required elements of those statements. Clause 2, the parties may submit with their statements all documents they consider to be relevant, or may add a reference to the documents or other evidence they will submit. 2A, this has been added as an amendment. The respondent in support of his case may also submit a counterclaim or plead a set-off which shall be adjudicated upon by the arbitral tribunal if such counterclaim or set-off falls within the scope of the arbitration agreement. Last clause, third, unless otherwise agreed by the parties, either party may amend or supplement his claim or defense during the course of the arbitral proceedings, unless the arbitral tribunal considers it inappropriate to allow the amendment or supplement having regard to the delay in making it. Now, as we've already seen, that the claim, the statement of defense, the counterclaim or set-off, or the documents which the parties intend to rely, or at least a reference to those documents. Now, for these, there are IBA rules on taking evidence. which have been considered as a soft law amongst all nations across the board. Now, these rules also provide certain ways by which these documents or oral evidences can be brought on record. Once the claim or the statement of defense has come, unless the parties have agreed contrary, amendments can be allowed. But during those amendments, the tribunal or the arbitrator looks into one aspect very categorically. Let's say party A has submitted a statement of claim and party B has submitted its counterclaim along with the statement of defense. Now, party A files an application for amendment of statement of claim. The tribunal or the arbitrator will have to test one thing, that the amendment shall not be of such a nature that it brings a new, fresh claim altogether. So the amendment has to be an ancillary amendment, which is the part of the arbitration agreement or part of the dispute for which this arbitral tribunal or the arbitration proceedings have been initiated. Similarly, for the statement of defense and counterclaim amendment also, the amendment shall not be such that it intends to change the whole nature of defense, or it brings on record such a new counterclaim which was not discussed or not thought about. So that's one restriction which is placed upon the parties while bringing amendments, as it has been referred in the subclauses. Now, the IBA rules, very interestingly, so far as documentary evidence is concerned, says that apart from the documents which the party has submitted, the other party may give a list of documents which it intends to seek from the claimant or the defendant, as the case may be. So, for example, the defendant may approach the arbitral tribunal or the arbitrator saying that this is the list of documents which I request you to direct the claimant to bring on record, because it is the claimant who is in possession of these documents and I am not. Now, the moment arbitrator looks at the list, the arbitrator may or may not direct. But the only test is that the arbitrator must be convinced that these documents are irrelevant. They have no relevance to the present dispute. Then only he can say that no, these documents are not required. But if the arbitrator thinks that these documents are relevant to the present dispute, then the arbitrator may direct the other party to bring on record those documents. Now, apart from this, the other party also has a right to decline and say that no, we will not bring on record these documents. The other party may say so on the basis of what grounds? It may say because it may say that it lacks of sufficient relevance, or that there is a legal impediment, or these are certain documents which are of very confidential nature, or that it may say that it has lost the document, or the documents were very old and they have been destroyed or destructed, or it may say that these documents are of certain political nature that we may not bring on record. And then the IBA rules very categorically again says that the arbitrator or the arbitral tribunal has then the power to rule on those objections. And the parties are bound by those orders which are passed by the tribunal or the arbitrator. When the arbitrator says that no, all your objections, they are futile, and I subsequently direct you to bring on record, then the parties will have to bring on record those documents. So this is so far as our section 23 is concerned. Now moving to section 24. 24 talks about hearings and written proceedings. Now this, I would say, is the heart of this chapter, section 24, because it is here that the real proceedings after the submission of the claim and the statement of defense and the documents and everything, it is here that the proceedings in effect for adjudication start. So what does it say? Let's read it. Section 24, clause 1, it says, unless otherwise agreed by the parties, party autonomy, the arbitral tribunal shall decide whether to hold oral hearings for the presentation of evidence or for oral argument, or whether the proceedings shall be conducted on the basis of documents and other materials. So it also says that the parties have the right to choose that they don't intend for oral arguments, whatever documents have been given, they are sufficient. Then there's a proviso which says, provided that the arbitral tribunal shall hold oral hearings at an appropriate stage of the proceedings on a request by a party, unless the parties have agreed that no oral hearing shall be held. Then there's a second proviso which has been added by an amendment in 2015, which says, provided further that the arbitral tribunal shall, as far as possible, hold oral hearings for the presentation of evidence or for oral argument on day-to-day basis, and not grant any adjournments unless sufficient cause is made out, and may impose costs including exemplary costs on the party seeking adjournment without any sufficient cause. Clause 2, the parties shall be given sufficient advance notice of any hearing and of any meeting of the arbitral tribunal for the purposes of inspection of documents, goods, or other property. Clause 3, all statements, documents, or other information supplied to or applications made to the arbitral tribunal by one party shall be communicated to the other party, and any expert report or evidentiary document on which the arbitral tribunal may rely in making its decision shall be communicated to the parties. So all that this section 24 says is that it is a party autonomy, and the parties have decided that they don't intend for oral hearings, then the documentary evidence also shall be sufficient. But if there is no such request made, then the arbitral tribunal or the arbitrator may fix a date, may fix a proper procedure, and may direct the parties that on this date, recording of the evidence will happen. On this date, oral hearings will happen. As the second proviso we've seen has been added by the 2015 amendment, which says that recording of the evidence and presentation of evidence or for oral arguments, they shall be held on a day-to-day basis. This is only to bring speed to the proceedings, because it was found that even during arbitration proceedings, at times parties will appear and they said that the witness is not available, that today the witness missed his flight, that today the witness missed his train, today the counsel is not well, or the arbitrator would say that, okay, I have examined one witness, now the examination of the second witness will happen after 15 days. So such problems were being faced by the parties. So only to avoid these situations, this second proviso has been added under section 24, which says that all these miscellaneous tasks during the evidence should be done on a day-to-day basis so that time can be saved. All right. So in this, see, the agreement between the parties is so important that recently in a 2022 SCC 279, this is Jagjit Singh Lyalpuri versus Unitop Apartments and Builders. This is a very recent judgment by the Supreme Court where Justice A.S. Bopanna has written the opinion. What happened in this is that when the statement of claim and defense and everything was filed and documents were presented before the arbitrator and the tribunal, then the parties said that we don't intend to cross-examine or take any oral examination of the witnesses. So whatever documents are with you, you read them and fix a date for oral hearing, final hearing. Accordingly, the tribunal decided a particular date for final hearing, and the hearing was done, award was passed. Now, once the award was passed, one of the parties realized that had it cross-examined a particular witness, then the finding of the arbitral tribunal could have been controverted. So it challenged on that basis. So before challenging it actually approached the tribunal and said that kindly recall that order and let us cross-examine that. So the arbitrator said that because I have already passed, so under section 32, I have terminated the arbitral proceedings and I cannot pass any other order. So then they approached the High Court and subsequently the Supreme Court. When the matter reached the Supreme Court said that no, having agreed between both of you, the parties, that you don't intend to cross-examine the witness, you have actually stopped your right. So the section is very categorical that if you would not have agreed, then you had all the rights. but you waived your right, and having waived the right, the award is passed. Now at the stage of appeal, 34, 37 level, you cannot say that I should be allowed to cross-examine. So of course, there is party autonomy. That party autonomy is under the limitations of the law or the statute which is provided. So it cannot so happen that you waived certain things, and once the proceedings have finished, then ultimately at the end you may again arise and say, no, sorry, I skipped it. There's a mistake on my end. Let me cross-examine him again. By this time, the award is already passed. So these things also are important. That is why these provisions are important. Thereafter, there is section 25, which talks about default of a party. So what default of a party says is, unless otherwise agreed by the parties, where without showing sufficient cause, A, the claimant fails to communicate his statement of claim in accordance with subsection 1 of section 23, the arbitral tribunal shall terminate the proceedings. B, the respondent fails to communicate his statement of defense in accordance with subsection 1 of section 23, the arbitral tribunal shall continue the proceedings without treating that failure in itself as an admission of the allegations of the claimant, and shall have the discretion to treat the right of the respondent to file such statement of defense as having been forfeited. C, a party fails to appear at an oral hearing or to produce documentary evidence, the arbitral tribunal may continue the proceedings and make the arbitral award on the evidence before it. So all that 25 says is that it's not as if you've invoked the arbitration proceedings and the arbitrator has been appointed and the arbitral tribunal has been constituted, then you are at your leisure, that you're very relaxed, that now because I have as per section 21, the proceedings have commenced, so there is no limitation running against me. I will file my statement of claim whenever I wake up from my slumber sleep. It's not like that. This 25 categorically says that if you, as the claimant or the petitioner, do not file your statement of claim within a prescribed period of time or within a reasonable time, having sought an extension or two, then the arbitral tribunal and the arbitrator is well within its power to terminate the arbitration proceedings. In the case of defendant, it says that if the statement of claim has been filed and the defendant takes unreasonable time in filing its statement of defense, then also the arbitral tribunal or the arbitrator is well within its right to proceed ex parte, or if not ex parte, to say that your right to file statement of defense has been forfeited. And thereafter, even if you file a recall application, he may dismiss it. He may say that the reasonable opportunity was given to you and you did not file your statement of defense. Now I won't grant you an opportunity. So this section 25 is a mechanism by which parties are put to strict notice that even if the arbitration proceedings have been initiated, even if the arbitration has commenced, it does not mean that whenever you feel like you will file your statement of claim or the statement of defense, that you will have to be reasonable in filing your statement of claim or statement of defense. You cannot delay it beyond a reasonable point. In this regard, there arose a question before the Supreme Court in SREI Infra Finance Limited in 2018-11 SCC 470, where what happened is that the tribunal terminated the arbitral proceedings because of non-filing of statement of claim. Now, once the proceedings were terminated, the claimant filed a recall application before the tribunal and said that kindly recall that order and take my statement of claim on record. The tribunal then passed an order on that application saying that having terminated the proceedings, I am not within my powers to recall this application. And subsequently, the matter reached the Supreme Court. Justice Ashok Bhushan, who was dealing with the matter, appointed an amicus curiae, Mr. Rakesh Dwivedi, and heard the parties on this issue, that whether when under section 25A, if the arbitral tribunal or the arbitrator has terminated the proceedings, these terminations are equal to 32 terminations. Section 32 termination is when the arbitral tribunal or the arbitrator has passed the award, and when he sees that the whole rationale or reason because of which this arbitral tribunal or the arbitrator was appointed has come to a conclusion and the award is passed, then he terminates the proceeding. So the Supreme Court framed an issue saying that 25A termination, which happens because of a default of a party, and 32 termination, which happens because the proceedings have come to an end, whether they are same or not, because it is obvious that after 32 termination, the arbitrator has fulfilled his obligation. So, and thereafter he has no other power to pass any other order. So it is here, after hearing the parties, that the Supreme Court said that 25A termination is different from 32 termination. That 25A termination, even if the arbitrator says that the proceedings have terminated because of lapse or default on because of one party, but still the arbitrator is well within its rights to recall the order, because obviously it is not an award. The award would have been when the claim was filed and the arbitrator would have applied his mind on the claim. But here, because the claim itself was not filed and because of a default of the claimant, the arbitrator terminated. So that's why the Supreme Court distinguished 25 and 32 in this regard. So the next two sections which are left under this chapter are section 26 and 27. 26 talks about expert appointment by arbitral tribunal, and 27 is one provision which I was saying that we will see that in this chapter also there is a provision which definitely takes recourse to the procedure, which is CPC or the Evidence Act. Why I am saying this, we'll look into it. First of all, let's read section 26 first. 26 says expert appointment by arbitral tribunal. Clause 1, unless otherwise agreed by the parties, the arbitral tribunal may A, appoint one or more experts to report to it on specific issues to be determined by the arbitral tribunal, and B, require a party to give the expert any relevant information or to produce or to provide access to any relevant documents, goods, or other property for his inspection. 2, unless otherwise agreed by the parties, if a party so requests or if the arbitral tribunal considers it necessary, the expert shall, after delivery of his written or oral report, particular in an oral hearing, where the parties have the opportunity to put question to him and to present expert witness in order to testify on the point at issue. 3, unless otherwise agreed by the parties, the expert shall, on the request of a party, make available to that party for examination all documents, goods, or other property in the possession of the expert with which he was provided in order to prepare his report. Now, this 26 is very similar to our section 45 of the Evidence Act, which talks about expert witness. But here it is the expert. Any party may request for an expert, or at times the arbitral tribunal or the arbitrator also has the power that if he so feels that there is a necessity of an expert opinion or an expert witness, then the arbitral tribunal or the arbitrator may on its own decide that for this particular issue or for this particular information, we will need an expert witness, and he may request or call for that. Now, once the procedure is all that once the expert witness has come and has given his report, the other party may definitely ask for all the documents or the material which was provided to the expert witness for reaching that conclusion. So the other party has been given this power because the other party may then object and say that the material or the documents which are provided to the expert witness are themselves not sufficient to reach a conclusion or are different from what they are claiming here. So this provision is important for that. Now, the last section why I said is important is this: court's assistance in taking evidence. This section is important because in a civil court or a criminal court, when the proceedings are going on, you will see that the courts have power to issue summons to witnesses, and the witnesses will have to appear before the court. But before an arbitral tribunal or an arbitrator, it may so happen that a party says that we need Mr. X to come and depose before the tribunal because he's a relevant witness. But Mr. X may say that I won't come. After all, it's an arbitral proceedings. And the arbitrator does not have those punitive powers like the civil court or the criminal court, which may issue then non-bailable and bailable warrants to witnesses if they don't come. So what will happen then? So that's why, as a precaution, section 27 is given under this chapter, which says that those witnesses which are material for the determination or adjudication of a dispute before the arbitral tribunal and the proceedings, and if the tribunal or any of the parties may think that this witness is essential for the determination, and the witness denies or declines to appear, then 27 can be taken recourse of. It simply says, Clause 1, the arbitral tribunal or a party with the approval of the arbitral tribunal may apply to the court for assistance in taking evidence. 2, the application shall specify the names and addresses of the parties and arbitrators, the general nature of the claim and the relief sought, the evidence to be obtained in particular, the name and address of any person to be heard as witness, the description of any document to be produced or property to be inspected. 3, the court may, within its competence and according to its rules on taking evidence, execute the request by ordering that the evidence be provided directly to the arbitral tribunal. So the court has then the power that upon such application being made, the court may say that such evidence may be produced directly before the arbitral tribunal. 4, the court may, while making an order under subsection 3, issue the same processes to witnesses as it may issue in suits tried before it. So that's why I was saying. So, however, 19 says that CPC is not applicable, but 27(4) again brings in record the action of the courts, and it says that while summoning or issuing summons to that witness, it shall issue the summon in the same way as it issues summons in a civil suit or such proceedings. Then 5 is the punitive action. Persons failing to attend in accordance with such process, or making any other default, or refusing to give their evidence, or guilty of any contempt to the arbitral tribunal during the conduct of the arbitral proceedings, shall be subject to the like disadvantages, penalties, and punishments by order of the court on the representation of the arbitral tribunal as they would incur for the like offenses in suits tried before the courts. So those punitive powers which are given to courts in general, if the witnesses do not appear, have been here mutatis mutandis being given in this provision. Last clause says, in this section, the expression processes includes summons and commissions for the examination of witnesses and summons to produce documents. So section 27 brings end to our chapter which we were dealing with, conduct of arbitral proceedings, where it says that if a witness which is essential and he declines, then the parties may approach courts, and the courts will then direct that person the way it directs in its civil proceedings to appear before the tribunal and depose. So with this, we come to an end of our today's session. Thank you so much.
Thank you so much, sir. That was quite insightful. So we have a few questions. Can I take them one by one?
No, please go ahead.
So the first question is whether arbitral tribunal is bound by the advice or opinion of the expert. Can he deviate from the opinion of the expert? If yes, under what circumstances?
See, so far as this is concerned, the opinion given by the expert, the arbitral tribunal is not bound by the opinion given by the expert, but it obviously has certain value, like your section 45 under the Evidence Act. You will see that similar principle will apply in arbitral proceedings also. In section 45, the Evidence Act, even if the expert has given its opinion, then also the courts are not bound by that opinion. Similarly, the tribunal also will not be bound by that opinion. It will only have certain value, value which is more than a normal person says, but it's not bound by. Even in your section 45, when an expert opinion deposes before the court is never bound by that opinion.
Thank you, sir. So the next question is whether an award is subject to challenge under section 34 if the agreed procedure is not followed.
Yes. That's a very well challenge. Obviously, it is considered as a misconduct. Under section 18 also actually violates the equality clause. If the parties have agreed to a particular procedure and the arbitral tribunal or the arbitrator does not agree to that procedure, it is a misconduct. So it is definitely a valid ground for challenge.
So there's a question related to this. Whether the challenge to an award under Section 34 of the Act operates as automatic stay.
No, I can't see the question. What are you saying?
Sir, we had received it.
No, I am sorry. It does not operate as an automatic stay. You will have to definitely move a specific application in that regard, and only if that application is allowed, the stay is granted.
Okay, sir. So we have received one more question, which is whether the power under Section 8 is available to appellate courts, revision courts too.
8. What is it?
Power to refer the matter to the arbitration.
Let me just see whether the power under Section 8 to refer the matter to the arbitration is available to appellate courts to see. Power to refer matters to arbitration to appellate courts and revision courts would not arise, because the appellate courts or revision courts may refer the parties for mediation, not for arbitration. Arbitrations happen only in cases where the parties have agreed for arbitration. All right. So the appellate court during an appellate proceedings cannot refer parties for an arbitration. All that the court may say that you may both sit for a mediation and see if there's an amicable settlement can happen between you or not. That will not be arbitration.
Okay, thank you, sir. Sir, we had received one more question which said, in what circumstances can a party that is not a party to an arbitration agreement be joined to the arbitration proceedings? So basically, can a third party become a party to an arbitration proceeding under any circumstances?
The power will be definitely with the arbitral tribunal, but I do not think it is possible, because it is it is not possible. Only a circumstance which I can see is the group of companies doctrine, where the parties can establish that if the arbitration is going on between A and B parties, and the third party which wants to enter is either a part of group of companies or is affected by one of the parties which were a part of group of companies. I think this has already been discussed by my friend in previous sessions, the group of companies doctrine.
Yes, sir. Sir, can I take one last question? So the last question is, what are the challenges for examination and cross-examination of witnesses in arbitral proceedings via video conferencing?
There'll be no different challenges, the same challenges as they arise in all other proceedings during the video conferencing. I don't think that that is still happening so far as courts are concerned. And in arbitral proceedings, so far as I am concerned, I haven't heard that being happening yet. So can't say. Otherwise, it's really difficult, because when a witness is being examined, you will see that basically all four of them have to be actively participating, the one asking the question and the lawyer at the other side and the arbitral tribunal. So like in the courts, I still have not seen cases during arbitral proceedings where examination of witnesses are happening. See, and it's really difficult, because during examination of a witness, there are certain things, there are certain important aspects which may not be available during a video conferencing, like the expression of the witness when you're about to ask a question, or when you have in your mind a series of questions through which you intend to trick the witness. That may not happen during a video conferencing, because you will not be able to get the best expressions of the witness. So it's really very difficult during a video conferencing to ask questions from a witness.
Thank you so much, sir. So looks like we have covered all the question. Before we wrap up the session, is there anything else that you would like to add?
I think I've said whatever was needed. Thank you so much.
Thank you so much, sir, for such a knowledgeable session. I would also like to thank everyone for being a part of this lecture today. We hope to see you all tomorrow for tomorrow's session. Thank you once again. Thank you, sir.
Thank you.